5 seconds to go. Start. Whether the policy which makes a provision for remission of sentence should be that which was existing on the date of the conviction of the accused, or it should be the policy that exists on the date of consideration of his case for premature release by the appropriate authority. The respondent was convicted under sections 302, 148 and 149 of the Indian Penal Code and sentenced for life imprisonment. Having served more than 10 years imprisonment, the respondent approached the High Court as, in spite of having undergone the sentence as per the policy of the government, his case for premature release was not being considered in view of a new policy on short sentencing. The High Court held that the case of the respondent for premature release was to be considered in the light of the short sentencing policy existing on the date of his conviction and directed the state authorities to consider within a period of 1 month his case for premature release. Aggrieved thereby, the state government preferred appeal before the Supreme Court. The Supreme Court held that the case of the respondent was to be considered on the strength of the policy that was existing on the date of his conviction. The power of the sovereign to grant remission is within its exclusive domain, and it is for this reason that our constitution makers went on to incorporate the provisions of Articles 72 and 161. The act of remission of the state does not undo what has been done judicially. The punishment awarded through a judgment is not overruled, but the convict gets benefit of a liberalized policy of state pardon. Even if a life convict does not satisfy the requirement of remission rules or short sentencing schemes, there can be no prohibition for the president or the governor of the state to exercise the power of clemency under the provisions of Articles 72 and 161 of the Constitution. Whether pregnancy of a woman who is a victim of a rape and is mentally retarded be terminated even though she had expressed her willingness to bear a child. An orphan and mentally retarded woman who is an inmate of a government run welfare institution located at Chandigarh had become pregnant as a result of an alleged rape. After the discovery of her pregnancy, the Chandigarh administration had approached the High Court seeking approval for the termination of her pregnancy. The High Court directed the termination of the pregnancy, although the victim had expressed her willingness to bear a child. Aggrieved thereby, the appellant moved the Supreme Court. The Supreme Court held that there is no doubt that a woman's right to make reproductive choices is also a dimension of personal liberty as understood under Article 21 of the Constitution of India. The crucial consideration is that a woman's right to privacy, dignity, and bodily integrity should be respected. There should be no restriction whatsoever on the exercise of reproductive choices such as a woman's right to refuse participation in sexual activity, or alternatively the insistence on use of contraceptive methods. The reproductive rights include a woman's entitlement to carry a pregnancy to its full term, to give birth, and to subsequently raise children. However, in the case of pregnant women, there is also a compelling state interest in protecting the life of the prospective child. Therefore, the termination of a pregnancy is only permitted when the conditions specified in the applicable statute have been fulfilled. The court observed that the findings recorded by the expert body which examined the victim indicate that the continuation of the pregnancy does not pose any grave risk to the physical or mental health of the victim, and that there is no indication that the prospective child is likely to suffer from a congenital disorder. The court directed that the best medical facilities be made available so as to ensure proper care and supervision during the period of pregnancy as well as for postnatal care. Since there is an apprehension that the women in question may find it difficult to cope with maternal responsibilities, the chairperson of the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities to look after the interests of the women in question, which will include assistance with child care. Stop.